This week, the High Court handed down a dangerous decision that institutionalised racial identity politics in our Constitution. They created a unique category of persons previously unknown to the laws of this nation. The new category comprises those who are neither Australian by birth nor have acquired citizenship by taking the Pledge of Allegiance. Such people have always been aliens, and indeed are in most nations on earth. In her sober dissent, Chief Justice Susan Kiefel indicated that her colleagues were engaging in judicial activism by purporting to discover implications never intended to be derived from the actual text of the Constitution. Ultimately, the Australian people are the custodians of our Constitution through the amendment provisions in section 128. I doubt whether a majority of them will be thrilled to learn that two violent criminals who were neither born here nor ever felt sufficient attachment to Australia to apply for our citizenship have escaped deportation through an incredibly expansive interpretation of Indigenous identity. Make no mistake, this decision does not honour Indigenous identity in any meaningful way for most Indigenous Australians. Rather, it undermines what it means to be an Australian. Here's what Home Affairs Minister Peter Dutton had to say on the decision this week.
It's a 170-page judgment, and the Attorney-General, our General Counsel within Home Affairs, having a look at it obviously at the moment. I think there's significant repercussions, and essentially it creates another class of people.
The court has done this at a time when a sense of shared national identity in the face of common peril has never been more crucial to our survival. The majority of the High Court opted for the vibe of the Mabo decision, as that fictional lawyer Dennis Denuto in the Australian classic The Castle might have called it. But as many real jurists would say, they have merely embarked upon taking us down a slippery slope.